It's 2:15, and I'm pleased to introduce to you our second and final panel, Hot Topics in Pennsylvania Courts. You have before you the Honorable Kevin Brobson from the Commonwealth Court, the Honorable Victor Stabile from the Superior Court, and our moderator, Linda Kerns, in whose capable hands I now leave you. Thank you.
Good afternoon. I'm Linda Kerns, and our panel is on hot topics in Pennsylvania courts. And for the uninitiated, in Pennsylvania we have two statewide intermediate appellate courts. We have the Commonwealth Court, which is unique to Pennsylvania, and our Commonwealth Court is responsible for original civil actions brought by and against the Commonwealth of Pennsylvania. The Commonwealth Court also addresses appeals from decisions made by state agencies and the courts of common pleas. And that court was established in 1968. The Superior Court is responsible for appeals in criminal and most civil cases from the Court of Common Pleas, as well as appeals on matters involving children and families. And that court was established in 1895. And practically speaking, the Superior Court issues the final ruling on most legal disputes, as many petitions for review to our Supreme Court are denied, so the Superior Court stands. So today we have, as Matt announced, we have two judges, one for each of the courts. The Honorable Kevin Brobson from the Commonwealth Court and the Honorable Victor Stabile from the Superior Court. So I suggested they just kind of duke it out so we know which one is better, but they came up with this whole list of very interesting academic topics. So the first thing that we're going to discuss is the Environmental Rights Amendment, education funding, and right to know.
Well, she stole my thunder on that. I thought I was going to, give you the topics as I went and these hot topics in the Commonwealth Court. But first, I'd like to thank the Federalist Society. I'd like to thank Linda. But it's a real honor to be here to participate in this discussion with you today. And I'd like to thank my good friend from the other Intermediate Appellate Court in Pennsylvania, Judge Stabile, for participating in this with me. At the Commonwealth Court, our jurisdiction is really focusing on cases where the legality of governmental action is called into question. And that runs the gambit from issues relating to taxation, to local zoning matters, to the constitutionality of particular actions, legislative or administrative. So the advertised subject or topic that we're supposed to talk about today is hot topics in Pennsylvania courts. And as you can imagine, there are many hot topics going on in the Commonwealth Court of Pennsylvania, so I'm sure you're all on the edge of your seats ready to talk about these. I was listening to the comments from the panel this morning, and Justice Wecht actually rattled off a lot of the cases, or the actual cases that I'm going to talk to you about today. So I like to think we're going to be consistent with those. I'm not going to overtread on what he said, but maybe put a little bit of meat on the bones from what Justice Wecht commented on. So the first topic that came to mind when I thought of hot topics was congressional redistricting. We're going to save that one for a little bit later in our discussion, so I'm going to avoid that one for now. But the other one that came up was the Environmental Rights Amendment. And in 1971, the voters of Pennsylvania ratified the Environmental Rights Amendment to the Pennsylvania Constitution, and it's found in Article 1, Section 27. The Environmental Rights Amendment provides that the people have a right to clean air, pure water, to preservation of natural, scenic, historic, and aesthetic values in the environment. And then it provides Pennsylvania's public natural resources are the common property of all the people, including generations yet to come. As trustees of these resources, the Commonwealth shall conserve and maintain them for the benefit of all people. In its 2017 decision in Pennsylvania Environmental Defense Foundation versus Commonwealth, the Pennsylvania Supreme Court held that common law trust principles apply to the duties conferred on the Commonwealth in that provision. And the court further held that the Commonwealth includes all agencies and entities of the Commonwealth government, including state and local governmental entities. The obligation under Article 1, Section 27, according to the Pennsylvania Supreme Court, is twofold. First, it's to prohibit degradation, diminution, and depletion of public natural resources, whether directly by state action or indirectly by the action of private parties. And second, it's to act affirmatively by legislative action to protect the environment. These were new pronouncements by the Pennsylvania Supreme Court, a whole new interpretation of the Environmental Rights Amendment, and it breathed new life into this constitutional provision that had been on the books for about 45 years. And the decision spawned, as you can imagine, new litigation, and it also spawned new arguments in historically common litigation. Issues that are topics in our court or will be topics in the years to come as we flesh out the Commonwealth or the Supreme Court's PEDF decision include what obligations does it impose on actual local agencies or officials, particularly in the areas of zoning. So zoning was considered a power, but it wasn't ever considered a mandatory duty. If you look across the Commonwealth of Pennsylvania, there are many municipalities, particularly in western Pennsylvania and northern Pennsylvania, that have absolutely no zoning laws whatsoever. You can put anything anywhere you want to put it. So in light of Article 1, Section 27 and the Supreme Court's new interpretation of that provision, what must local agencies do in the areas of zoning in order to exercise their duties and obligations as trustee? Another issue that's going to come up is the standard of review. If everyone is the Commonwealth of Pennsylvania in all aspects of government, who gets the final say on whether a particular action or inaction violates Article 1, Section 27? If it's the courts, are the courts supposed to afford deference to the elected officials in the General Assembly that might do some sort of a balancing and might arrive at some view on how to protect the environment, but also on how to encourage development of natural resources or a person's individual right to use their own property the way they choose? These are questions that our court is going to struggle with in light of the PEDF decision. The other question is, does the Commonwealth include those who act with governmental authority? So for those that you view that operate in the public utility realm, public utilities operate by the grace of the government. So the question is, do they have any Article 1, Section 27 obligations under the Pennsylvania Constitution? There's certainly going to be other questions that are raised, but those are kind of the topics that we're dealing with or are likely to deal with in the future. It was a momentous decision by the Pennsylvania Supreme Court, and I'm sure that the reach and scope of that decision is going to be litigated in our court and in the local courts for years to come. The next one is education funding, and Linda mentioned it and Justice Weck mentioned it. It's the William Penn School District education decision. These were constitutional challenges to the method and amounts of funding established by the General Assembly for the public schools. This issue had long been considered non-justiciable, had long been considered a purely political question. The conclusion was based, at least in part, on the education clause of the Pennsylvania Constitution, Article 3, Section 32, which vests exclusively within the General Assembly the duty to, quote, provide for maintenance and support of a thorough and efficient system of public education. It was also premised in part on the notion, moored in precedent, that a judicial standard or benchmark for what is a, quote, thorough and efficient system could not be devised without supplanting the discretion of the judicial branch for that of the General Assembly. The William Penn School District case, the Pennsylvania Supreme Court paved a new path. They criticized prior precedent and held instead that it was at least theoretically possible for a judiciary to set constitutional guardrails for how the General Assembly can exercise its discretion and determine what is a thorough and efficient system without violating the separation of powers. And with that, the Supreme Court remanded the matter back to the Commonwealth Court, which is actually pending now in our original jurisdiction, where we've been directed with the assistance of counsel and discovery and whatever experts can come forward to try and create those guardrails. The William Penn decision is one of those decisions from the Supreme Court that I refer to as those drop the mic moments. The Pennsylvania Supreme Court is a court of discretionary review, except when they review matters that come from our court's original jurisdiction. They generally paint in broad brushes. So they make broad pronouncements of law. It's really the role of the Superior Court and the Commonwealth Court to a certain extent, and the trial court judges to a lot of the extent to actually finish out the margins with the finer brushes. And that's what we're seeing in the William Penn case, and that's what we're seeing in the PEDF case. Another case that comes to mind is the right to know law decisions in Pennsylvania and the Pennsylvania Supreme Court's decision in the PSEA matter. So it comes as no surprise to anybody in this room that government is collecting and holding information that is personal to everybody. And it's extensive amounts of personal information. Information from the employees, information from people that do business with the Commonwealth of Pennsylvania, information that people that just want to do business with the Commonwealth of Pennsylvania. That personal information may or may not be private. In PSEA case, the Supreme Court, on appeal from a decision of our court in our original jurisdiction, considered the question of whether home addresses of public school teachers should be exempt from disclosure under the right to know law based on a constitutional right to privacy. The argument was there was a constitutional right to privacy in the Pennsylvania Constitution and that home addresses should be exempt. Up to that point, for a long period of time, the Commonwealth Court had made the decision that home addresses were ubiquitous at this point in time. Home addresses are not necessarily private information, and it had consistently rejected claims to the contrary. In fact, the Commonwealth Court had relied on a 2003 decision from the Pennsylvania Supreme Court called Commonwealth versus Duncan. A search and seizure case, yes. But the Supreme Court concluded in that case that in a modern society, a person's name and address is not information about which a person can have an expectation in privacy that the public is willing to recognize and protect, which is a play off of the Fourth Amendment cases from the United States Supreme Court, U.S. versus Katz, and the like. In PSEA 3, though, the Supreme Court took a different tack. They reversed us and they concluded that home addresses enjoyed privacy protection under the Pennsylvania Constitution and that the public's interest in disclosure did not outweigh that interest. How the Supreme Court got there is a little bit interesting. First, they reviewed the development of tort-based privacy concepts, meaning privacy between individual citizens, really first raised in an article in the Harvard Law Review in 1890 called simply The Right to Privacy, written by Samuel Warren and Brandeis. And it was a landmark article that ended up being the basis for future restatement provisions that we now have embedded in laws throughout the country dealing with right to privacy. They also talked about privacy in the context of search and seizure under the Fourth Amendment and the Pennsylvania's equivalent under Article 1, Section 8 of the Pennsylvania Constitution. And then they talked about the penumbral privacy cases from the United States Supreme Court to illustrate how privacy interests actually extend beyond the context of search and seizure cases. Ultimately, the Supreme Court settled in on a Pennsylvania constitutional provision, Article 1, Section 1. As being a source of a broad right to informational privacy. And Article 1, Section 1 provides that all men are born and equally free and independent and have certain inherent and indefeasible rights, among which are those of enjoying and defending life and liberty, of acquiring, possessing, and protecting property and reputation, and of pursuing their own happiness. It sounds a little like penumbral privacy, at least to me. For anybody that is a textualist, you're kind of looking for the word privacy. You don't necessarily see it there. But the Supreme Court certainly had the precedent available to it to read into this provision some general protection for people's privacy, which they did. And so what the Supreme Court said was even if this information is not exempt specifically under the right to know law, agencies still have to do a balancing test to determine whether the information is entitled to constitutional protection, and if so, whether the public's interest outweighs it. So what the Supreme Court did was they effectively reversed the Commonwealth Court. They held that an individual has a right to informational privacy. They held that the public school teachers had a strong right to privacy in their home addresses, that there was no countervailing interest or need of the public to know the home addresses of school teachers, and that was the end of the case. At least from the Pennsylvania Supreme Court, it was the end of the case. As cases go forward now, we are seeing other types of information that people are saying that the government possesses that enjoys some constitutional protection of privacy. So some noteworthy comments about the PSEA case. The Supreme Court blended tort and constitutional concepts of right to privacy while at the same time seemingly endorsing a notion that some information can be private under one aspect of the Constitution, meaning this Article 1, Section 1 right, but not private under another section dealing with Fourth Amendment search and seizure, which seems to suggest that the Pennsylvania Supreme Court believes that privacy is contextual, meaning some information is private given under certain circumstances, but not private on others. The court did not arrive at any analysis that can give guidance on how to determine whether private information or whether personal information is private. So there's still a question as to how they reached the conclusion that home addresses of public school teachers enjoy a strong privacy right. Then the question is, in light of PSEA 3, are there remedies? Because under the right to know law, an agency may choose to disclose this information, and if they do, are they violating the Constitution? And then, of course, we have the same standard of review question, which is who gets the final say? And with that, I mean, I could go on. We could have CLE on each one of those cases and the subjects that the Commonwealth Court wrestles with day in and day out. But I'd love to hear from my colleague, Judge Stabile, on the things that the Superior Court is facing.
Thank you. Let me first say it's an absolute pleasure to be here today to present in front of the Federalist Society, especially with my good friend and colleague, who I do admire, Judge Brobson, and at the kind invitation here of Linda Kerns and Josh Wilson. Okay, not enough time to really get into the weeds on topics that are hot in the Superior Court, but what I'd like to do is at least maybe alert you to what really is happening right now, where changes are occurring, where if you're practicing in that area, you really do need to be able to look at current case law. Today, everything has become so much more complicated that I remember 30 years ago, you'd be able to pick up the advance sheets once a week and read them from cover to cover. Today, you can spend your entire day keeping track of changes in the nuances in the law. It's almost insurmountable, but the time needs to be made. So what I'm trying to do is identify areas, so if you're interested, you can go take a look here because there are changes happening. First, before I begin, can I just get sort of a sense, how many people practice criminal law here? Okay, good enough. How about family law? All right, and civil. Okay, good. That'll help me parse my topics. All right, in the criminal law area, the court has been challenged in the past several years on a line of cases that began in 2000 called the United States versus Apprendi, and then in 2013, United States versus Elaine. These were cases that basically said that at sentencing, if there's any fact that will increase your punishment, increase the minimum or increase the maximum, it has to be found by a jury. That significantly upset the sentencing schemes before trial courts. Those issues have to go to a jury. We had another case that said then that many of our mandatory sentencing statutes really were not severable anymore, so they had to be put on the side. That caused district attorneys to abandon mandatory minimums in order to pursue the statutes in a way that sidestepped that problem. I will tell you that whenever we get faced with a major decision like that, and there are several others that have come down following on that line of logic, Commonwealth versus Muniz, Commonwealth versus Butler, those were Sorner cases, sexual crime cases. We always are faced, and you need to be aware of how these apply while an appeal is pending, whether it's direct appeal or on collateral review. There are much different considerations that determine your right to raise those issues in the context of those proceedings, as well as, the difference between collateral and direct proceedings on those, and whether or not what you're talking about is punishment. The legislature has attempted to amend those laws in order to cure that. Those issues are now before our court, will no doubt go to the Supreme Court. It's yet to be decided. Fourth Amendment, if you take a look at what the Supreme Court has done this year, you're seeing a shift in terms of Fourth Amendment. Remember, Pennsylvania puts a greater emphasis on privacy than it does on police deterrence. When you look at where the jurisprudence is this year, you're seeing a shift more towards privacy and more restraint on police action. PCRA procedure continues to be a bugaboo. You really need to study that if you practice in that area. 404B evidence, very fact-specific, very much looks at the discretion of the trial judge. This is your wrongful acts and your prior bad acts evidence. Case called Hicks. You need to study it. it can be a very slippery slope. If an error is made, it's prejudicial almost per se. In the family law area, termination of parental rights, right to counsel. We are going through a number of cases right now trying to discern the extent of the right to counsel under Section 2313 and really what a court has to do to avoid a remand on that. The right to counsel in the family area is almost tantamount now to the right to counsel in the criminal law area. That's the way it's being viewed. Civil law, very important decisions on discovery rule right now. The Supreme Court came out with one this past week in the med-mal area. If you do that, it's worth studying in terms of the standard that you look at on due diligence or reasonable diligence. We're still looking to see how the tincture line of cases will shake out. The Supreme Court decided tincture and basically said, we're going to let the case law develop. They did away with the fiction that products liability has nothing to do with negligence, acknowledged that it grew out of negligence law. The question now is to what extent negligence law will become a part of products liability law. Arbitration, wrongful death and survival cases, they now can be split because of preemption under the FAA federal law. Justice Weck wrote that decision. Area that you really need to look at, these are really new situations but old rules. Authentication of electronic evidence. Same rules apply. We are not like the federal court. The federal court has come up with special rules. Our Supreme Court has said no. Our rules are broad enough in order to look at this kind of discovery or evidence. Our case law is addressing how you lay the foundation for electronic evidence. You need to study that. More and more evidence, I think, that will be coming in will trigger that area. And finally, we are now seeing activity in the mass tort area, especially involving jurisdiction. The Supreme Court decided a case called Bristol-Myers, which has now said that definitively has said that for state jurisdiction to apply, you have to tie that to your cause of action. And from there, a very long story ensues. We have so much more to talk about, but hopefully I've scratched the surface and gave you at least some idea, if you're in those areas, what you should at least need to be looking at least for this week. Thank you.
Right, but don't go anywhere.
Okay.
As you all know, in Pennsylvania, we elect our judges. We elect Supreme Court judges, Superior Court judges, Commonwealth judges, Common Pleas judges. And that is somewhat unusual that all of our judges are elected. As you may have heard, there is a push for merit selection, at least at the Superior Court and the Supreme Court level. So Judge Stabile is going to talk briefly about that topic.
Okay. The issue of merit selection versus elections, it's been debated for quite some time. Advocates on both sides of the issue. I know that the people in the audience today are familiar with the issues both for and against it. The most significant activity, though, was House Bill 111 that came in during the session of 2017, actually came off the table late in the session this year, died by the cessation of the legislative session, still to be seen if that will be introduced. Notably, the bill is not called a bill for merit selection. It is called a bill for selection of judges, and that'll become apparent in just a few minutes. But when you take a look at this issue, I'm not going to give you my opinion one way or the other, but I'm going to suggest what it is that the objective is that should be looked at. When people talk about selection of judges or election of judges, they're really focused upon the evils of campaigning and money and that type of influence. You really don't hear, though, the discussion being focused on examining the quality of the judges that have been produced out of the electoral system. Nor do you really hear that being discussed out of the merit selection system. There are recent writings that have said that there has been no definitive study to date to say that there is a discernible difference between quality of judges coming out of either selection system. But in 1968, the people of Pennsylvania said, we want our judges elected. By the way, that passed, my understanding is by a very narrow margin from the convention floor. So, objective when you take a look at this, what is it that you're trying to achieve? Do you want to get rid of the political aspect of it, or are you looking at the quality of the individual that comes out of it, or perhaps are you looking at both? The legislature has crafted a bill, really, if you go behind it, to address political circumstances. This bill did not just come out of a sense of magnanimity. All right? There were political circumstances in Pennsylvania which encouraged or was the impetus for members in the legislature to come up with this proposal, and they all have their reasons. The reason why I mention that is because when you look at this bill, You cannot look at it holistically and say, this is a bill free of politics that just looks at selection of judges. It is a product of the political process. And when you read through the bill, and I'll go through the highlights of it in a minute, it really is a combination of merit selection and election of judges. It is a hybrid, in my opinion. And it is not called a bill for merit selection, as I said before. It is called selection of judges. So to echo Justice Weck and Judge Sutton, who was here before, the principal question that we should be looking at is who gets to decide our cases, hence this process. All right, so what this bill attempts to do is to amend Article 5 of the Pennsylvania Constitution. Now, I'm going to leave the intricacies of that on redistricting later if we dare go to that point. But in any event, what it does is principally, it now creates judicial districts. Now, when I go through these points, in the back of your mind, consider, are these merit selection criteria or are these election criteria contained within the bill? In many respects, the bill mirrors an election process, and then in other respects, it is a selection process itself without election, and it does blend the two. But it amends Article 5 over here to create, for the first time, judicial districts in Pennsylvania. And coincidentally, the bill talks about districts that are compact, contiguous, approximately equal in population. I see my friend Judge Brobson smiling over here. All right, not unnecessarily splitting municipal boundaries. Why does that sound familiar? I think that word redistricting looms in the background. But you can see if you're creating judicial districts, what are you doing? You're entering into that legislative process in order to select judges, that third branch of government. So it creates eastern, middle, and western districts. From the Supreme Court, 7 justices. By the way, the number of judges don't change under this bill. 2 justices from each of the 3 districts, and then 1 elected statewide. Superior Court will have 5 districts, and Commonwealth Court will have 3 districts. Okay, 5 in each, there will be 5 elected from each in the Superior Court and 3 elected from each district in Commonwealth Court. So what does that suggest? It suggests a representative form of judges, a perfect blending of selection of judges with the election of judges. Okay, it then leaves the transition or the logistics of that to the legislature. For common pleas judges, they remain elected under this bill. And probably because people at that level get to know you. Thank you. I will just simply mention this on leaving the election of judges in there at the local level, where people get to know you best. There was a very well-known and old-time party chairman that I had the fortune to know, and sat me down one day and said, well, he says, Vic, sometimes when people get to know you, they vote against you. Perhaps maybe that's why common pleas judges remain elected. People have the chance to get to know that person in their community, and they can vote on an educated basis. Probably the most predominant feature is the Appellate Court Nominating Commission. It is appointed by the legislative leaders in the Senate and the House. If any of you have ever been involved in gaming, I leave you to reflect upon that experience on whether that became political or not. Terms of office are the same. Initial term is for 4 years, and then retention for 10 years. The first 4 years is by appointment. I question whether that's the best system if you're going to try and lure people out of, say, private practice, who have to give up a practice and only stay a judge for 4 years, take the risk of an election, and if you lose, have to go back and try and build a practice in again. Just a question I raise in terms of if we're trying to get the best people possible in the best design system, whether that makes sense. So with that, that should give you a flavor of what's there. It may be dead for now, but I suspect someone else will introduce it in the next session. All to stay tuned for a later time. Thank you.
So we're going to move on to redistricting, but before we do that, because we have a Commonwealth Court judge and a Superior Court judge, I thought it would be interesting to just, if they would discuss briefly the... I swear, you give a lawyer a microphone and then, that's just the end of it. The decision-making process and what cases get heard en banc, how many judges are on panels. So we can start with Judge Brobson.
I think we agree that we're going to do sort of a rapid fire format, and Vic's going to start, and then I'm going to tell him why how the Superior Court does it is wrong and how we do it is right. So I think, with all due respect to Judge Beck, who's sitting here, I mean that with a lot of respect, Judge Beck.
It's all right, Judge Brobson. I have 5 cases we're going to transfer to your court tomorrow.
Okay, let's go.
All right, starting from the beginning here, notice of appeal to the trial court to get to my court versus a petition for review in Commonwealth Court. 2 entirely different procedures. Mine is fairly simple. You just have to attach the right papers. Judge Brobson, petition for review is more complicated.
Petition for review is more complicated, but there's been an amendment to the rules that make it a little bit easier. As all of you who appeal know, the biggest issue when you're representing a client in an appellate case is waiver. Waiver was long an issue and a concern in petitions for review. That concern has pretty much gone away at this point in time. But the petition for review certainly has to have more in it than a notice of appeal. Here's a little practice tip for everybody who is up against the gun and a client calls you on the last minute before a petition for review is due in our court, not a notice of appeal. File the notice of appeal anyway, because the worst thing that's going to happen is we're going to hold your file date and send it back and have you file a petition for review. See, we're nice, Vic. Okay. We're nice.
The Superior Court has been criticized for being aggressive on waiver. Unfortunately, we've been told that in many instances it is jurisdictional. We need to take notice of it sua sponte, and it's a hard way to lose cases, and it's disheartening to see it. But if you want to save that appeal, look in the rules for use of the Postal Form 3718. You can use it in order to file a petition for review to the Commonwealth Court. You cannot use it in order to hold a filing date in a trial court in order to get to Superior Court.
Yeah, this is the mail rule. If for some reason your petition for review or your notice of appeal, I guess petition for review arrives late, we'll look for a mail date, but you have to have that form, so look for that form. There's one minor exception, and that's if you look at the date that it was received by the court and there's intervening holidays or something like that, then you can usually backtrack and it's obvious that it was mailed on time. But other than that, make sure you're using that mail form.
Yeah, and just a little tip, if you do, because it can save a date, not only should you enclose a copy of the form with what you mail to the court, you should have a duplicate copy stamped to keep in your record so you can produce it in case you get called on it. All right, I guess the next thing that really is a difference between our 2 courts is how cases are selected for oral argument or submission on briefs. In the Superior Court, we leave it to the practitioners to elect whether they want oral argument or to submit on briefs. And we can discuss probably for at least an hour on the pros and cons of doing either one of those things. But you get a letter from the Superior Court, and then you elect, and that's how you get it. And in an oral argument, you're entitled to 15 minutes on a standard argument, but if you want to go expedited, you get 5 minutes, and the bonus is that you jump to the head of the list. I have personal qualms with attorneys that do that when 5 minutes is not enough to present your argument, and you have a case where the court really wants to be informed about your issue. I think you really bump up into the ethical rules when you elect 5 minutes in order to get out of the courtroom earlier, especially since you've spent a couple of years on a case. How about selecting in your court?
Well, I agree with the 5-minute rule. I argued one case in Superior Court before I went on the bench. I was convinced by the local attorney down in Philadelphia to go on the 5-minute list. I got up there and said, "May it please the court, my name is Kevin Brobson. I'm a shareholder with Buchanan, Ingersoll, and Rooney. With me is my colleague, my associate. Thank you, Judge. Thank you very much, Mr. Brobson." And it was done. So do not, practice tip, don't take that 5-minute thing no matter how much they tell you to. In terms of selection, Commonwealth Court's practice has changed over the last couple of years. We used to be very selective in the cases that we heard for oral argument. We now presume that with the exception of pro se cases and certain types of unemployment comp cases, if a case is counseled, we'll list every case for argument. Whether a case goes to en banc argument list or panel argument list depends on the nature of the dispute and the profile and nature of it, whether there's something we want to clear up in the precedent. Sometimes cases will get through en banc going through our judicial conference process, which we'll probably talk about. But otherwise than that, there's a presumption that every case is going to be argued. If your case gets on an argued list and you want to submit it, file an application, and we'll consider it.
All right, since you're all here today, I'll let you in on a little secret about electing oral argument in the Superior Court. If you elect oral argument in the Superior Court, you will undoubtedly get more time from the judges that will be deciding your case, because a case that's set for oral argument will come to the judge who will prepare it before oral argument, will study it, will be prepared to ask you questions. The case will be deliberated between the panel members after the argument before a writing is issued. We have a very heavy caseload. We've been told we have the most of any appeals court in the United States. But that's not to say if you submit a case that it's not going to be properly decided, or at least attempt for us to properly decide it. It will get the attention it deserves. But if you want to get some more of our time, oral argument's the way to go. En banc consideration is very different between our two courts. Where the Commonwealth Court, as you just heard, will select cases for en banc consideration, that is not possible in the Superior Court purely because of how decentralized the judges are and how many cases we have. After a panel decides a case in the Superior Court, if you disagree with the decision, you can file a re-argument petition. By doing that, the panel will have a chance to take a look at what you say you think the panel got wrong. When the panel is done with it, it will then get circulated to all the other judges who will now see the decision for the first time. And if you get a majority of the judges on the court to agree that it should be reheard, then 95% of the cases, that's how a case gets to en banc consideration in the Superior Court. The advantage is that by asking for re-argument, you're now getting the attention of all the other judges on the court who have not yet seen your case. That's different in your court, Kevin.
In our court, as I mentioned, we do select cases as soon as they are filed, whether they are going to be en banc or panel or SOB. And en banc is 7 out of our 9 commissioned judges. What we have that is very different from the Superior Court is our judges, ever since the inception of the court in Constitutional Convention in 1968, and when the first truly merit-selected judges were put on the court in 1970. If you want to see an example of merit selection, look how the judges, the original judges of the Commonwealth Court were selected. It's truly amazing, the quality and where they came from throughout the state, their backgrounds. That was a lesson in merit selection right there. But in any event, one of the things that our court has done from its inception is our judicial conference process and our voting process. An opinion does not get issued by a panel of our court or the court en banc without every commissioned judge reading and voting on it. Every commissioned judge, whether they're on the panel or not, reads an opinion as it's circulated full court and has the opportunity to lodge an objection to it or to vote that they agree to it. And when they lodge an objection, they can put a comment down on it. If a panel opinion gets 4 objections from 9 of the commissioned judges, then that goes to judicial conference, which we hold every argument session. We travel together. We're with each other much more often than the Superior Court judges are. And we sit around a conference table and we hash it out. And if after that 5 commissioned judges disagree with the proposed majority, that case will be listed for en banc consideration. So, real good tip. Read our internal operating procedures. You will see how we operate. We're not hiding anything. We have it in our internal operating procedures. If you have argued a panel case already, you've appeared in front of a 3-judge panel and you've argued, and you get a notice that it's going to be re-argued before the court en banc, that's why it happened. It happened because it went through the judicial conference process, and there is not some level of agreement among all the commissioned judges.
So the chances of filing a re-argument petition after you get a panel decision from 3 judges is pretty low.
Re-argument petitions in the Commonwealth Court from a panel decision are rare because every commissioned judge has already reviewed the opinion, and at least the majority of the judges have signed off on it.
Whereas in the Superior Court, especially if you get a split decision, that will catch the attention of judges more likely in order to look at it and say, you know, is there a split of authority, or is this something that all of us should take a look at? It hasn't been decided yet. Identification of panel judges, very big difference between the 2 courts. The Superior Court will post online the argument panels, the cases that will be heard, and what judges will be on that panel at least, I think, 6 or 7 weeks out from argument. You will also get a letter telling you that within 2 weeks of you being notified of that argument schedule, you have to notify the court if you believe you need a continuance, whether that be for scheduling, for recusal, or otherwise. That is our practice, and principally in order to ferret out those trouble cases which should not be heard by that panel. Very different from Commonwealth Court.
We like to keep the mystery going. We try not to tell anybody who our panel judges are until you get there. I mean, there's an obvious reason for that. If we put our panel judge lists out there, you could potentially invite recusals as soon as they see the panel judges, or you could invite Worst, continuances, where people see a panel judge and they want to try to play the panels, so they'll ask for a continuance. If you want a continuance in our court, do not wait till the last moment. Nothing riles us more when we get a continuance request at the last moment. And if you're going to request a continuance, make sure you ask the other side. Usually, if a continuance is unopposed, it's going to be granted. That's just, my general practice is if the lawyers agree to everything, they'll get virtually everything they want. I was a lawyer at one point in time in my life, so I completely understand that. I like the lawyers to run their cases, even their appellate cases, to the extent they can. That being said, our decisional process, too, is very swift. We issue opinions after they're submitted, either to argument or a submitted panel within 90 days of it being submitted. That's actually our average over the last several years has been 75 days without a minority opinion. 90 days is the goal that the ABA sets out for time to disposition, so we're pretty proud of that statistic. And I think a lot of it has to do with the way that we do select our cases and the way that we do move things on.
In the Superior Court, if you ask for a continuance, we generally are very amicable to entertaining that on the first basis. Depending on how much time you look for, you may not be so lucky, but generally, especially you have concurrence of counsel, a request for a first continuance will be granted. Note, in children fast-track cases, because of the emphasis on trying to achieve permanency as soon as possible, those time frames are significantly shortened, so any extra time you get is going to be less than any other case that's before the court.
I'll give you this one additional practice tip and warning for those who come to the Commonwealth Court. If you ask for a last-minute continuance and both parties agree to it, you risk your case getting submitted, because that's another option that the court considers.
Okay, good. How much time do we have left on this topic?
Just a minute or two.
A minute or two. Frequency of 1925B statements, because 95% of all cases come to my court from appeals from trial court decisions. Rule 1925, which requires the appealing party to file a statement of what they're complaining about and then a trial judge to produce an opinion in response to that, is central to practice before the Superior Court. It is jurisdictional. Those timeframes are strictly construed as per our Supreme Court. You need to pay strict attention to those. Any request for an extension of time has to be made before your time expires, or you may be out of luck. I will tell you one of my pet peeves about the rules, not only here, but in a lot of other rules, is that they're supposed to be designed to streamline the moving of cases through the court and to provide order in how cases progress. Unfortunately, the rules have become a trap for practitioners. They have become so minute, and a number of the rules you really do need to take a look at case law in order to see how they're interpreted, that there are many traps out there. If you're not familiar with the appeal process, do yourself a favor. As soon as you think you're going to be looking at an appeal, get somebody who has appellate practice to make sure you don't lose your case before you even get started.
Not a big fan of 1925. I wasn't a fan of it when I was a lawyer. I'm not a fan of it when I'm a judge. I think it imposes too much of an obligation on some common pleas court judges who have incredibly huge dockets, particularly here in the city of Philadelphia or in Allegheny County, our major metropolitan areas. I think there's a waiver trap. My view of it is any issue you preserve on the record below is an issue that you can raise on appeal. And 1925 to me just puts too much risk and too much time for the trial court judges and too much risk for the lawyers. So if there's one rule I could get rid of if I could, my magic wand, it would be 1925.
Yeah. And that continues to be a very hot topic in the Superior Court.
We tried, by the way. Justice Wecht isn't here. The Superior Court and the Commonwealth Court, so all of you know, we have tried to bend 1925 every possible way you can imagine to bend it. We don't like waiver. We have tried to do it. And every time we have done it, the Supreme Court took the case and they said it's jurisdictional and it's mandatory and so we have tried. So don't hold us accountable.
Yeah. And by the way, if the trial court disregards the time frame, understands your issue and decides it anyhow, the Supreme Court says it's still jurisdictional, doesn't count. It's a hard way to lose a case. Are we on to the next topic, Linda?
Yes, because we want to leave time for questions at the end. So the next topic is redistricting. As I think by now everyone in the country knows, the League of Women Voters sued the Commonwealth of Pennsylvania regarding the legislative map that had been drawn by a Republican-controlled legislature in 2011 that reflected the 2010 census. The suit alleged that it was an unconstitutionally drawn map that benefited Republicans. The Supreme Court of Pennsylvania, which was controlled 5-2 by Democrats after a sweep of 3 seats in the 2015 elections, fast-tracked the case and tasked Commonwealth Court Judge P. Kevin Brobson.
No, my PJ picked me.
Oh, I thought that
Lucky
was
me.
Oh, there you go. With hearing evidence and issuing findings of fact and conclusions of law before the end of 2017. Judge Brobson wrote that the plaintiffs had shown that partisan considerations were taken into account in creating the map, and that more politically neutral maps could have been drawn that would not have been as favorable to the GOP. However, he noted, some degree of partisanship is considered acceptable in redistricting, and the plaintiffs had not created a judicially manageable standard for the court to decide whether the map crossed the line. He noted that the petitioners failed to meet their burden in proving that the 2011 plan, as a piece of legislation, clearly, plainly, and palpably violates the Pennsylvania Constitution. He said that for the judiciary, this should be the end of the inquiry. This was Pennsylvania, so it was not. After appeal, the Pennsylvania Supreme Court, relying on state law, imposed a new congressional map as a remedy after ruling that the Republicans had unlawfully redrawn the state's districts to maximize the Republican gains. The new map drawn by the court, instead of the legislature, supposedly was based on criteria like geographical compactness, which you heard Judge Stabile discuss, instead of partisan advantage. The Democrats applauded the map. The Republicans called the new map the ultimate partisan gerrymander, one brought about by the Democratic governor acting in concert with liberally politically connected litigants. So we'll start with Judge Stabile's comments on this case.
Well, you know, the case is very challenging from a lot of perspectives. Other than the merits, there are a number of issues raised on the case, and I'm looking at it really as a student of the decision, not as the author or, you know, on the Supremes having ultimately decided the case. But it certainly raises questions of not only interpretation of the Pennsylvania Constitution, but its interplay with the federal Constitution, federalism, and one point that I wanted to really make, it demonstrates, I think, a trend, if not an increase in the trend, of our Pennsylvania court, and whether that's an exercise of, you know, protecting its turf or a way of deciding cases, of really deciding cases under the Pennsylvania Constitution, and that insulates review from the federal courts, in this case, the Supreme Court in particular. When you take a look at the redistricting case, there were state and federal issues that were raised by the litigants in that matter. Our Supreme Court cast aside the other issues that were raised in favor of deciding that case purely under the Pennsylvania Constitution, under a clause that said that the people in this Commonwealth were entitled to free and equal elections. Correct, Judge Brobson?
Correct.
Okay. And in those 3 words, they generated a very lengthy decision which talked about the history of that clause in Pennsylvania, the fact that Pennsylvania's Constitution didn't succeed the federal Constitution, but is the ancestor to the federal Constitution. So it had the right to take a look at our own history in terms of interpreting that clause, and went back and discerned a number of neutral principles which they felt fell underneath that phrase of free and equal elections, allowing it to be able to set forth neutral criteria not only for future cases, but in order to be able to find the districts, the map from 2011 to be unconstitutional. But what I thought was interesting was the use of the Pennsylvania Constitution more frequently in this Commonwealth. Now, if you look at the federal courts, there seems to be a tendency that when the federal courts don't want to decide a case, they kind of toss it out on issues like standing. You know, some people will call that judicial economy. But I know when this case went into the federal arena, they tossed it out on standing grounds. I remember in the 2012 presidential election, when the qualification of people on the ballot were challenged, the federal court likewise threw those out on standing. But in Pennsylvania, if you notice, even fairly recently, looking from 2013 forward to the present, the Robinson Township versus Commonwealth of Pennsylvania case, which Judge Brobson talked about on the Environmental Rights Amendment, that was a case that raised both state constitution and federal constitutional arguments, substantive due process. The court went off and decided that purely under the Pennsylvania Constitution in order to be able to free the municipalities from the state regulating entirely the area of oil and gas drill willing. When you take a look at the Fourth Amendment, there is not just one case, but you will see a number of cases where our Supreme Court has decided our equivalent of the Fourth Amendment in terms of the greater protection of privacy, as I said before, versus deterrence, which is the principal objective that the feds look at under the Fourth Amendment. I mentioned the Muniz case before. That was a case which originated out of the United States Supreme Court precedent. When it came to Pennsylvania, the question was whether our sexual offender statute, our SORNA statute, was unconstitutional under Muniz when they applied it retroactively as violative of the ex post facto clauses under both the Pennsylvania and United States constitutions. Although both clauses, I believe, were deemed to be coterminous in many respects, the court only gathered a majority saying that it violated Pennsylvania's ex post facto law. It also violated the federal ex post facto law, but the court did not gather a majority on the principle that Pennsylvania's ex post facto provision provided greater protection than the federal Constitution. So even though in that case it was affirmed by decided by a majority on coterminous grounds, there was still a push to find a greater right under the Pennsylvania Constitution as dispositive of the issue in that case. And then, of course, we get to the League of Women Voters case, which is all to say that I think you're seeing an increasing trend of our Supreme Court to look to our state constitution, I guess pretty much in line with what Judge Sutton was talking about before, to look to decide our cases as opposed to looking at federal constitutional law. And whether that's purely as a matter of jurisprudence or to, end review, well, I guess you have to look at each case to make that determination if you want to go past the plain writing itself. But the case also, Kevin, separation of powers, still an undecided issue.
Well, so the procedurally how the case came up is a little bit interesting because it was at the time that Gill versus Whitford and other challenges were pending in front of the United States Supreme Court. And when the case was commenced by the League of Women Voters in my court's original jurisdiction, we stayed the matter. We stayed the matter pending resolution by the Pennsylvania Supreme Court. And we felt this was consistent with the prior Veith versus Jubileer case and the other cases where the redistricting was challenged in the past. Let's wait to see what the Supreme Court did. The Pennsylvania Supreme Court, though, does have a history of stepping out in front of the United States Supreme Court, particularly where the United States Supreme Court does ultimately what it did in Gill versus Whitford, which was punt, delay, not decide, primarily because they couldn't get a majority of justices to rule in a particular way. So the Supreme Court was a little bit prescient when they took King's bench of the case and then sent it back to the Commonwealth Court to have a commission judge do the findings of fact and conclusions of law. The conflict that case was really about was the conflict between the United States Constitution and this idea that, which I think is true, that the state courts of Pennsylvania can decide whether legislation passed by the General Assembly is constitutional or not constitutional. The United States Constitution vests within the general legislatures of the states the obligation to craft the congressional districts subject to any rules and regulations that Congress will pass. Congress hasn't had any rules on the books with regard to congressional districts for quite some time. There's some rules with regard to as close to equal representation as you possibly can, and of course you have the Civil Rights Act and things like that. But in terms of compactness, contiguousness, not splitting counties, not splitting districts, all of those have gone by the wayside in terms of a mandatory test. Many states have constitutional provisions that specifically prohibit state legislatures from using political considerations in crafting congressional districts. Pennsylvania doesn't have them. Many states have congressional district commissions that are supposed to draw districts and their standards that go with those. Pennsylvania doesn't have that. So what you're really left is with every other ordinary, regular piece of legislation that the General Assembly passes, and therefore, is it constitutional? Which is really the heart of the question. What the Supreme Court did, which it is entitled to do, I can't question the wisdom of what they did. They interpreted a provision of the Pennsylvania Constitution, the Free and Equal Election Clause. Granted, it had never been previously interpreted in the way that they interpreted it, but they interpreted it the way that they felt it should be interpreted, and they applied it to basically rule a piece of legislation unconstitutional. That's what they did. In a way, it was an ultimate act of federalism by looking to the Pennsylvania Constitution and having a state court decide the issue. The only unresolved, I think where there could be some fair criticism of the Supreme Court, and I certainly wouldn't lob it, but there could be some fair criticism is, there was precedent from 1991 where you had a divided General Assembly and governor. And after the census, they could not agree on congressional districts. And people brought an action, so they couldn't pass the legislation to create the congressional districts for the 1992 election. Voters brought an action in the Commonwealth Court's original jurisdiction. We issued an order in mandamus that said, do your job, right? Do your job, General Assembly, do your job, Governor, do a map. Ultimately, they couldn't do their jobs. They couldn't come up with a map. It came back to our court and said, well, they couldn't do their job. The Supreme Court took King's bench of that, and then the Supreme Court sent it again to the Commonwealth Court as sort of a hearing officer role, which is what I had. And that Commonwealth Court judge, the president judge at the time, David Craig, actually had a hearing, took evidence, reviewed, he asked for submissions of map proposals. He received 6 alternative congressional maps. He had hearings on those 6 maps where people could raise objections, bring in experts, any number of things, and ultimately Judge Craig considered everything and recommended one of those 6 maps to the Supreme Court for its consideration, and the Supreme Court ultimately affirmed that. I think that's the process that the Supreme Court should have followed in the League of Women's Voters case. It wasn't, but I think that would have been the appropriate way to draw any remedial map.
We left a lot of time for questions, so does
We like questions, by the way. We don't like standing up here and talking. I'm sorry to interrupt you, Linda, I apologize, but as judges, we don't get a lot of opportunities to hear from lawyers and people in the community about feedback and questions that they have about how we do what we do and how we can do it better. So I personally look forward to this as an opportunity to have an exchange and conversation with you all about what you think about our appellate judiciary and what we can do better to serve you as attorneys and your clients. So I'm looking forward to hopefully a good discussion and a lot of questions. Or not.
Gentleman over here.
Oh, right, there you go.
Yeah, let me answer it this way. Okay. The question is whether the complexity of the law is getting to the point where, can that be changed so that it doesn't present the problems that I was talking about, in essence. Let me answer the question this way. I think what you're trying to do is put the genie back in the bottle. The law constantly evolves, and our precedent continues to grow. Probably some of the best advice I got years ago, I heard from a consultant talking about the problem you're discussing. The days of a general practitioner, I think are almost over. It's very, very difficult to stay current in, any, 4 or 5, any number of areas of law at the same time. They just continue to grow in complexity and in terms of rules. It's the nature of the beast. If you specialize in 1 or 2 areas or limit yourself to a couple of specialties, number one, it's going to free you from having to stay on top of that wealth of information in order to practice competently in all the areas you're trying to cover. Number two, when you specialize, you're going to get known to people as someone who specializes in that area, and that's great for marketing, because when someone has a problem, they say, well, who does that kind of work? If you're doing that kind of work all the time, your name's going to pop up, all right, as opposed to someone who tries to be a jack of all trades. The third thing is, if you move towards specialization, I believe you will find there are lower incidences of malpractice claims. Why? Because if you specialize, you're staying current, you know the area, and you're not prone to making the mistakes in so many other areas that you can't possibly stay on top of as a practitioner, given the evolving nature of the law and how complex it's becoming. Simple answer is, I don't see the law ratcheting back. I see practitioners having to adapt. Yes?
How does that affect the judges? Judges have to be generalists. How will they ever know when there are hundreds of thousands of laws and statutes?
Yep. Let me answer it this way. I have the good fortune from the time I wake up until the time I go to bed at night to live, breathe, eat, sleep, study, write, rewrite, and digest case law and precedent all day long on all of the areas you just talked about, and I have the good fortune to have 5 experienced professional law clerks to help me do that. I spend my days studying the law. In the course of a year, I will probably study 1,200 decisions or more. I will, on the panels that I sit on, I will review probably 900 decisions, almost 300 of which I will write from my chambers. The intensity of being able to look at that much volume of material day in and day out and not to be distracted by the pressures of practice and development, which you have to do on the outside, is what allows me to hopefully perform competently in all the areas we just talked about. Having said that, it's not as fractured as you think, especially in the criminal area. You see the same issues come up time and time again. You do become expert on that. You do become expert on procedure. There are the unique cases that do come up. Those take more of your time, but you have an institutional knowledge in order to be able to fall back on. So I guess what I'm saying is, I have the ability to devote all my time to studying and analyzing the law with the assistance of counsel in their briefs to be able to get to the point that you're concerned about, where I don't think people in practice have that ability. And we do eat, sleep, and breathe law day in and day out. I go home every night with a briefcase, even on weekends. I can't tell you that every night I open it, but a good number of nights I absolutely do, as I will this weekend. I will tell you, when I went on the bench, this is kind of crazy. For my first 2 weeks, I came out of 26 years of private practice, government before that. And for the first 2 weeks, I felt very unsettled, and I couldn't understand what was going on. And then I realized what it was, and I started laughing. I wasn't writing down my time, okay? I did not realize how ingrained that became as a practitioner. But when you stop, the clock stops. All right? As a judge, if I want to go back and study a precedent for 2 or 3 hours and revise what I'm writing and go back the next day and change it again, I don't have the pressure of who is going to pay me to do that. My time given to me by the people of this Commonwealth gives me the freedom to devote all of my energy into trying to correctly decide your cases free of those constraints that you have to face when you're in private practice.
Yep, I see a question in the back. I think there's a microphone right there if you want to use that so everyone can hear. Great.
You need to turn it on.
Or just speak very loudly.
All right, I'll just try to. Yeah.
Oh, yes.
So,
Good voice.
You'll have to excuse me because it's been months and months since I actually read the redistricting decision, and so if my understanding is incorrect, please first of all correct me on that. But my understanding was that, I'm good, I'm on a roll now. The court essentially, it seemed like they kind of got out in front of any question on whether they have the power to do, or the authority to do what they did, to actually redistrict the map. And if I'm saying correct, it said that it had the authority under statute that, and I don't remember the site, but under statute that essentially did support a very wide discretion in terms of making such orders or rulings that justice so requires or if equity requires. I guess first, it's my understanding.
I guess I've got to answer that one, huh?
Yep.
Okay.
You can kick it first.
No, that's okay. So I think what the principle was that the Supreme Court was embracing, I'm not sure it was embraced by reference to a statute, but I think what they were embracing was where there is a constitutional wrong, there must be a remedy. And that oftentimes that remedy has to be given by the courts. So, for example, I pointed out the 1991 situation where the General Assembly could not agree to a map that the governor would sign. Well, if you purely focus on the United States constitutional provision that says it's up to the legislatures to do this, and the legislature doesn't do its job, do we not have congressional races? Something's got to give way. Someone has to break the logjam. So I think what they were simply doing was taking this general principle of where there's a wrong, there must be a remedy, and saying, if not us, then who? Realize they didn't do it just right away. They gave the General Assembly and the governor a period of time. I understand some may think that it was a wholly inadequate period of time. I understand it may have been a farce because why would a Democratic governor agree to anything if the Supreme Court's going to draw the map? I understand all those arguments, but they at least did give the General Assembly and the governor an opportunity to draw a map before they felt that they had to give a remedy to the wrong. How far does that principle go? That goes into justiciability and the issue of political question, and we saw that we're probably going to run into that problem in the William Penn case. When you look at the William Penn opinion and the precedent before that, which basically said this thorough and efficient system of education is not justiciable. There's no standard that we can come up with. The Supreme Court basically says, well, we think you can, so try. Well, what if the standard then we come up with requires the General Assembly to appropriate a lot more money to certain disadvantaged school districts? And we say, okay, Commonwealth Court. Commonwealth Court says, go ahead, General Assembly, you need to come up with an extra $150 million to a particular school district. What do you think the General Assembly is going to say? We know what they're going to say because we have... Probably, which we don't have a lot left. but there's a history of this. There was, I forget, as a case that came out of Allegheny County, where there was a challenge to funding of state court systems. Judge Beck may remember this, where there was it was about the whole uniform judiciary. We have a uniform judiciary on the Pennsylvania Constitution, and the General Assembly therefore has to pay for it. Because it's a unified judiciary. It's a statewide judiciary. It's not county by county. So there was an action to get more funding for the unified judicial system, particularly to the counties. And the Supreme Court issued an order that basically said, General Assembly, go forth, give us more money. And the General Assembly said, no. And then years passed, and the Supreme Court issues another order and says, but we meant it. And the General Assembly goes, no. And then the Supreme Court did it one more time. Well, we really meant it. You need to give us more money. And they do this in orders, and the General Assembly goes, no. If you ask the Supreme Court justices that were around then, they just say, we tried, we gave up. I mean, at some point in time, you run up against something. I think the issue of whether the Supreme Court somehow violated the United States Constitution and even drawing the map may still possibly find its way to the United States Supreme Court. I think there might be petitions, 1 or 2 pending there that haven't been ruled on yet, but I'm not optimistic, particularly because it really was a state constitutional case by a state Supreme Court, and I don't know of too often where the United States Supreme Court has decided to weigh into that morass.
You know, if you, obviously the 800-pound gorilla lurking in the back of the room is the separation of powers doctrine. Whenever there's a constitutional violation, people expect that the courts are going to be able to order an appropriate remedy. What Judge Brobson has just illustrated to you is perhaps that's not always possible, but I don't believe our Supreme Court has reached that precipice yet. When you take a look at the federal Constitution, Article 4, which talks, which is the Elections Clause, and it allows Congress to have the states do time, manner, and place of elections right now. In the fine print, that also allows the states to be able to, under the federal Constitution, use its state constitution in order to be able to fulfill those functions. So, in a sense, the state constitutions, even under the federal Constitution, cannot be ignored, and I believe there's a case that speaks directly to that. But in the redistricting case, it was easy for the court to order something. It didn't require somebody else to act. They drew the lines and said, here it is. And we can debate that all day long on separation of powers. But in the money cases that Judge Brobson is talking about, what do you do? Like I said, we always want to believe that for a constitutional wrong, there is an appropriate remedy. This is not the first time this has come up, and to my knowledge, the Supreme Court has not yet cut that Gideon's knot.
We have time for one last question. So,
They could reach a decision in the election of March, and that may have spurred them on to come up with something.
You're talking about a single district, a single district election.
Around the Supreme Court said, we don't want to bother with this. The legislature came up with something, or was ruled unconstitutional. Everybody's elected in March.
There was a suggestion that if they didn't decide it, that the
I don't-
default would be at large.
That would have been interesting, wouldn't it?
okay, I want to thank
He's got one more.
Can we just
Oh,
get
I'm
that
sorry.
one-
Was there one? I
gentleman
didn't
back
see.
in the corner right
Oh,
now?
yeah, sure. Who were you pointing at?
I think him.
Okay, great.
Red tie. It's a red tie day.
Thank you.
Yeah.
Also.
Thank you.
Professor Samaha, Villanova Law School. I just had a question. So political scientists have said it doesn't matter ill beans how one is selected, whether through election or appointment, with respect to quality of the jurist. But what does matter is the back end. That is the sense of the insecurity of office and whether one needs to stand for election. And they say that the worst of all worlds is retention elections, because in retention elections, the odds that the jurist is actually turned out are very low. It's like 98% retention, and that's because you don't have any opponent that is motivated to generate information about the incumbent to turn them out of office. And so my question to you is, would you prefer, if there were contested elections, that it would simply be for a fixed non-renewable term of office, albeit lengthy, as sort of the best of all worlds, and there is some democratic input, which could be important because, after all, you have powers that are not just statutory but are common law, and so it's got a democratic pedigree then. And then independence is protected on the back end against the influence of donors and others because it's a lengthy, non-renewable term.
Basically, term limits for judges.
I'm talking about a lengthy term of office, but yes.
With a contested reelection. So there are those systems in the country, and we've seen, I think, Michigan, I think, is one. There's some states in the Midwest that have the long terms. What you see coming out of those cases is something I don't think any judge would like, which is basically, if you're a judge and you happen to issue one opinion that a lot of people don't like, you're probably going to get an opponent, and you're probably going to have that one decision thrown at you. Now, if it's a really
Non-renewable, right?
non-renewable. So once and done.
Become an arbitrator or mediator after and cash out and make money then.
Are you offering me a job? Wow. Yeah, that's interesting. I'll leave that to the political scientists. I grew up in north central Pennsylvania. I went to school at a small school in Williamsport, Pennsylvania. Harrisburg was far away from me. I lived in Montoursville, Pennsylvania, or I was down here in Philly visiting family. Those were the two places I was at, getting soft pretzels on the boulevard before the health department got at them. That's how I grew up. I'm not sure I ever envisioned running statewide for judge. It is not something that is for the faint of heart. But I do believe this. I have been in front of some great federal judges across the country, and I've been in front of some great elected state judges across the country. I've been in front of some pretty crappy federal judges across the country, and I've been in front of some pretty crappy state judges that are elected. I'm not sure any system is going to be perfect or make anybody happy. What I will say to all of you about judicial elections, though, is the one thing that seems to be missing is this, not back end, but front end. All you have to do is be a lawyer. And you don't even have to be that to be a magisterial district judge. And you have to be of a certain age. But the one thing that I see, one value in a potential selection process, is there's some minimum qualification, some benchmark that we can get at the beginning of the process to give candidates access. Because I'll tell you, during the election, people don't pay as much attention to judicial elections as they should. The media doesn't pay enough attention to them. You can't get your message out. People don't know about the voters. In the primaries, they look where they're from. They look for their gender. They look for their last name. They look for their party. And that's how people are picking judges. And we all need to do a better job as an electorate, as candidates, as the media, of making people know that these judicial races really matter in Pennsylvania. And we all need to do a better part of building up the profile for those.
Let me just also, I think your point is arguable, but consider what happens if you limit the term and then you're out, once and out, say 10 years. Look at the institutional knowledge and experience that you're going to lose on your bench. And after a complete turnover of people on your bench, what are you going to have? There are some great judges that, we really are sorry to see retire.
I'm just hitting my stride, and I'm in year 9.
Yeah, you know what? But your point about worrying about elections bears upon judicial independence. The Constitution shows its strength, in my opinion, in the best light when it protects that minority voice, that unpopular position, because everyone can do the easy ones. I hate to be cliche-ish, but sometimes you've got to decide that case that people don't like, but it's what the constitutional law requires. Now, you want to throw those people out, or do you want to keep that person on the bench because they have taken an oath and they are exercising judicial independence to apply the law and uphold the Constitution the way it's written and intended? I can tell you that, we've all decided cases that we don't like. A few years back, I throw out on double jeopardy grounds a case on someone who was on trial for third-degree murder. There was a mistake made. It was a constitutional error. It couldn't be corrected. That man walked. Now, do you think that was a popular decision with the people in that area of this state? It's what the Constitution required. By the way, it was upheld. Now, if that happens to happen in a year of a retention election or an election, do you want to punish a judge who stays true to their oath that way? I mean, there is no black and white answer to your question, but ultimately, it's, are we producing good quality people? I opened my discussion earlier about selection of judges on what is the objective you're trying to achieve. Everybody's looking at the evils of how you get on the bench. But can we really say the quality of our judges is bad enough that we have to change who's sitting on the bench? Even when you take a look, people ask us, well, I get asked, but isn't your court political? I say no. Of course it's not political. I mean, what's a political question on criminal cases, family law cases, civil cases? Now, every person is maybe wired in terms of their judgment a little different, so there's that area of judicial discretion, even in the appellate review process where judgment is exercised, and that's perhaps where you see the difference in judges, and in particular now in the Supreme Court, but we're not deciding those kinds of issues. But in terms of the quality of judges, can we say even the judges you disagree with do not, rise to the challenge? Do you really want to empty your judiciary and lose that institutional knowledge? It's really how you get on the bench that people are objecting to. So I think you have the cart before the horse. What is it we're trying to solve? And at the end product, who gets to decide? Justice Weck and Judge Sutton asked that question. That, in my opinion, is what matters most.
So leave it to the law professor to ask such a thought-provoking question at the end. Thank you for that question. So I want to thank our panelists, Judge Brobson and Judge Stabile, and we're going to move to our closing speaker.
Thank you.